8. Form of oath or affirmation to be made by the judges of a High Court I.A.B., having been appointed Chief Justice, or a Judge, of the High Court at, or of, do swear in the name of God solemnly affirm that I will bear true faith and allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and integrity of India, that I will duly and faithfully and to the best of my ability, knowledge and judgment perform the duties of my office without fear or favor, affection or ill will, and that I will uphold the Constitution and the laws. 4th Schedule. Allocation of seats in the Council of States, Articles 41 and 82, to each state or union territory specified in the first column of the following table. There shall be allotted the number of seats specified in the second column thereof opposite to that state or that union territory, as the case may be. 1. Andhra Pradesh, 18-2. Assam, 7-3. Bihar, 22-4. Goa, 1-5. Gujarat, 11-6. Haryana, 5-7. Kerala, 9-8. Madhya Pradesh, 16-9. Tamil Nadu, 18-10. Maharashtra, 19-11. Karnataka, 12-12. Orissa, 10-13. Punjab, 7-14. Rajasthan, 10-15. Uttar Pradesh, 34-16. West Bengal, 16-17. Jammu and Kashmir, 4-18. Nagaland, 1-19. Himachal Pradesh, 3-20. Manipur, 1-21. Tripura, 1-22. Meghalaya, 1-23. Sikkim, 1-24. Mizoram, 1-25. Arunachal Pradesh, 1-26. Delhi, 3-27. Pondicherry, 1 total 233. 5th Schedule. Provisions as to the administration and control of scheduled areas and scheduled tribes, Article 244, 1, Part A. General 1. Interpretation in this schedule, unless the context otherwise requires. The expression state does not include the states of Assam, Meghalaya, Tripura and Mizoram. 2. Executive power of a state in scheduled areas. Subject to the provisions of this schedule, the executive power of a state extends to the scheduled areas therein. 3. Report by the Governor to the President regarding the administration of scheduled areas. The Governor of each state having scheduled areas therein shall annually, or whenever so required by the President, make a report to the President regarding the administration of the scheduled areas in that state, and the executive power of the Union shall extend to the giving of directions to the state as to the administration of the said areas. Part B. Administration and control of scheduled areas and scheduled tribes. 4. Tribes Advisory Council. 1. There shall be established in each state having scheduled areas therein, and, if the President so directs, also in any state having scheduled tribes but not scheduled areas therein, a Tribes Advisory Council consisting of not more than 20 members, of whom, as nearly as may be, 3/4 shall be the representatives of the scheduled tribes in the Legislative Assembly of the state. Provided that if the number of representatives of the scheduled tribes in the Legislative Assembly of the state is less than the number of seats in the Tribes Advisory Council to be filled by such representatives, the remaining seats shall be filled by other members of those tribes. 2. It shall be the duty of the Tribes Advisory Council to advise on such matters pertaining to the welfare and advancement of the scheduled tribes in the state as may be referred to them by the Governor. 3. The Governor may make rules prescribing or regulating, as the case may be, a. Sets the number of members of the Council, the mode of their appointment and the appointment of the Chairman of the Council and of the officers and servants thereof. I. Sets the conduct of its meetings and its procedure in general, and a. Sets all other incidental matters. 5. Law applicable to scheduled areas. 1. Notwithstanding anything in this Constitution, the Governor may by public notification direct that any particular Act of Parliament or of the Legislature of the State shall not apply to a scheduled area or any part thereof in the State, or shall apply to a scheduled area or any part thereof in the State, subject to such exceptions and modifications as he may specify in the notification, and any direction given under this subparagraph may be given so as to have retrospective effect. 2. The Governor may make regulations for the peace and good government of any area in a state which is for the time being a scheduled area. In particular, and without prejudice to the generality of the foregoing power, such regulations may assents prohibit or restrict the transfer of land by or among members of the scheduled tribes in such area. Assents regulate the allotment of land to members of the scheduled tribes in such area. Assents regulate the carrying on of business as moneylender by persons who lend money to members of the scheduled tribes in such area. 3. In making any such regulation as is referred to in subparagraph 2 of this paragraph, the Governor may repeal or amend any Act of Parliament or of the Legislature of the State, or any existing law which is for the time being applicable to the area in question. 4. All regulations made under this paragraph shall be submitted forthwith to the President and, until assented to by him, shall have no effect. 5. No regulation shall be made under this paragraph unless the Governor making the regulation has, in the case where there is a tribe's advisory council for the state, consulted such council. Part 100. Scheduled Areas 6. Scheduled Areas 1. In this Constitution, the expression scheduled areas means such areas as the President may by Order 566 declare to be scheduled areas. 2. The President may at any time by order assents direct that the whole or any specified part of a scheduled area shall cease to be a scheduled area or a part of such an area. Assents increase the area of any scheduled area in a state after consultation with the Governor of that state. Assents alter, but only by way of rectification of boundaries, any scheduled area. Assents on any alternation of the boundaries of a state or on the admission into the Union or the establishment of a new state, declare any territory not previously included in any state to be, or to form part of, a scheduled area. Assents rescind, in relation to any state or states, any order or orders made under this paragraph, and in consultation with the Governor of the state concerned, make fresh orders redefining the areas which are to be scheduled areas. And any such order may contain such incidental and consequential provisions as appear to the President to be necessary and proper, but save as aforesaid. The order made under subparagraph 1 of this paragraph shall not be varied by any subsequent order. Part 500. Amendment of the Schedule 7. Amendment of the Schedule 1. Parliament may from time to time by law amend by way of addition, variation or repeal any of the provisions of this schedule, and, when the schedule is so amended, any reference to this schedule in this Constitution shall be construed as a reference to such schedule as so amended. 2. No such law as is mentioned in subparagraph 1 of this paragraph shall be deemed to be an amendment of this Constitution for the purposes of Article 368. 6th Schedule. Provisions as to the administration of tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram, Articles 244, 2, and 275, 1, 1. Autonomous Districts and Autonomous Regions 1. Subject to the provisions of this paragraph, the tribal areas in each item of 571572 Parts 1, 2 and IA and in Part 3 of the table appended to paragraph 20 of this schedule shall be an autonomous district. 2. If there are different scheduled tribes in an autonomous district, the Governor may, by public notification, divide the area or areas inhabited by them into autonomous regions. 3. The Governor may, by public notification, a cents include any area in 573 any of the parts of the said table, a cents exclude any area from 574 any of the parts of the said table, a cents create a new autonomous district, a cents increase the area of any autonomous district, a cents diminish the area of any autonomous district, a cents unite two or more autonomous districts or parts thereof so as to form one autonomous district, a cents alter the name of any autonomous district, a cents define the boundaries of any autonomous district, provided that no order shall be made by the governor under clauses C, D, E, and F of this subparagraph except after consideration of the report of a commission appointed under subparagraph 1 of paragraph 14 of this schedule. Provided further that any order made by the governor under this subparagraph may contain such incidental and consequential provisions, including any amendment of paragraph 20 and of any item in any of the parts of the said table, as appear to the governor to be necessary for giving effect to the provisions of the order. 2. Constitution of District Councils and Regional Councils. 1. There shall be a district council for each autonomous district consisting of not more than 30 members, of whom not more than 4 persons shall be nominated by the governor and the rest shall be elected on the basis of adult suffrage. 2. There shall be a separate regional council for each area constituted an autonomous region under subparagraph 2 of paragraph 1 of this schedule. 3. Each district council and each regional council shall be a body corporate by the name respectively of the district council of name of district, and the regional council of name of region, shall have perpetual succession and a common seal and shall by the said name sue and be sued. 4. Subject to the provisions of this schedule, the administration of an autonomous district shall, in so far as it is not vested under this schedule in any regional council within such district, be vested in the district council for such district, and the administration of an autonomous region shall be vested in the regional council for such region. 5. In an autonomous district with regional councils, the district council shall have only such powers with respect to the areas under the authority of the regional council as may be delegated to it by the regional council in addition to the powers conferred on it by this schedule with respect to such areas. 6. The governor shall make rules for the first constitution of district councils and regional councils in consultation with the existing tribal councils or other representative tribal organizations within the autonomous districts or regions concerned, and such rules shall provide for a. The composition of the district councils and regional councils and the allocation of seats therein. A. The delimitation of territorial constituencies for the purpose of elections to those councils. A. The qualifications for voting at such elections and the preparation of electoral rolls therefore. A. The qualifications for being elected at such elections as members of such councils. A. The term of office of members of 579 regional councils. A. Any other matter relating to or connected with elections or nominations to such councils. A. The procedure and the conduct of business 580 including the power to act notwithstanding any vacancy, in the district and regional councils. I. The appointment of officers and staff of the district and regional councils. 7. The elected members of the district council shall hold office for a term of 5 years from the date appointed for the first meeting of the council after the general elections to the council, unless the district council is sooner dissolved under paragraph 16, and a nominated member shall hold office at the pleasure of the governor. Provided that the said period of 5 years may, while a proclamation of emergency is in operation or if circumstances exist which, in the opinion of the governor, render the holding of elections impracticable, be extended by the governor for a period not exceeding 1 year at a time, and in any case where a proclamation of emergency is in operation not extending beyond a period of 6 months after the proclamation has ceased to operate. Provided further that a member elected to fill a casual vacancy shall hold office only for the remainder of the term of office of the member whom he replaces. 8. The district or the regional council may after its first constitution make rules with the approval of the governor with regard to the matters specified in subparagraph 6 of this paragraph, and may also make rules 583 with like approval regulating a. The formation of subordinate local councils or boards and their procedure and the conduct of their business, and a. Generally all matters relating to the transaction of business pertaining to the administration of the district or region, as the case may be. Provided that until rules are made by the district or the regional council under this subparagraph, the rules made by the governor under subparagraph 6 of this paragraph shall have effect in respect of elections to the officers and staff of, and the procedure and the conduct of business in, each such council. 3. Powers of the district councils and regional councils to make laws. 1. The regional council for an autonomous region in respect of all areas within such region, and the district council for an autonomous district in respect of all areas within the district except those which are under the authority of regional councils, if any, within the district, shall have power to make laws with respect to a. The allotment, occupation or use, or the setting apart, of land, other than any land which is a reserved forest for the purposes of agriculture or grazing, or for residential or other non-agricultural purposes, or for any other purpose likely to promote the interests of the inhabitants of any village or town. Provided that nothing in such laws shall prevent the compulsory acquisition of any land, whether occupied or unoccupied, for public purposes 586 by the government of the state concerned in accordance with the law for the time being in force authorizing such acquisition. A. The management of any forest not being a reserved forest. A. The use of any canal or watercourse for the purpose of agriculture. A. The regulation of the practice of jam or other forms of shifting cultivation. A. The establishment of village or town committees or councils and their powers. A. Any other matter relating to village or town administration, including village or town police and public health and sanitation. I. The appointment or succession of chiefs or headmen. I. The inheritance of property. A. Marriage and divorce. A. Social customs. 2. In this paragraph, a reserved forest means any area which is a reserved forest under the Assam Forest Regulation, 1891, or under any other law for the time being in force in the area in question. 3. All laws made under this paragraph shall be submitted forthwith to the governor and, until assented to by him, shall have no effect. 4. Administration of justice in autonomous districts and autonomous regions. 1. The regional council for an autonomous region in respect of areas within such region, and the district council for an autonomous district in respect of areas within the district other than those which are under the authority of the regional councils, if any, within the district, may constitute village councils or courts for the trial of suits and cases between the parties, all of whom belong to scheduled tribes within such areas, other than suits and cases to which the provisions of subparagraph 1 of paragraph 5 of this schedule apply, to the exclusion of any court in the state, and may appoint suitable persons to be members of such village councils or presiding officers of such courts, and may also appoint such officers as may be necessary for the administration of the laws made under paragraph 3 of this schedule. 2. Notwithstanding anything in this constitution, the regional council for an autonomous region or any court constituted in that behalf by the regional council, or, if in respect of any area within an autonomous district there is no regional council, the district council for such district, or any court constituted in that behalf by the district council, shall exercise the powers of a court of appeal in respect of all suits and cases triable by a village council or court constituted under subparagraph 1 of this paragraph within such region or area, as the case may be, other than those to which the provisions of subparagraph 1 of paragraph 5 of this schedule apply, and no other court except the High Court and the Supreme Court shall have jurisdiction over such suits or cases. 3. The High Court shall have and exercise such jurisdiction over the suits and cases to which the provisions of subparagraph 2 of this paragraph apply as the Governor may from time to time by order specify. 4. A regional council or district council, as the case may be, may with the previous approval of the Governor make rules regulating a. Since the constitution of village councils and courts and the powers to be exercised by them under this paragraph. A. Since the procedure to be followed by village councils or courts in the trial of suits and cases under subparagraph 1 of this paragraph. A. Since the procedure to be followed by the regional or district council or any court constituted by such council in appeals and other proceedings under subparagraph 2 of this paragraph. A. Since the enforcement of decisions and orders of such councils and courts. A. Since all other ancillary matters for the carrying out of the provisions of subparagraphs 1 and 2 of this paragraph. 5. On and from such date as the President may, 590 after consulting the government of the state concerned, by notification appoint in this behalf, this paragraph shall have effect in relation to such autonomous district or region as may be specified in the notification, as if. A. Since in subparagraph 1, for the words between the parties all of whom belong to scheduled tribes within such areas, other than suits and cases to which the provisions of subparagraph 1 of paragraph 5 of this schedule apply, the words not being suits and cases of the nature referred to in subparagraph 1 of paragraph 5 of this schedule, which the Governor may specify in this behalf, had been substituted. A. Since subparagraphs 2 and 3 had been omitted. A. Since in subparagraph 4 A. Since for the words a regional council or district council, as the case may be, may with the previous approval of the Governor make rules regulating, the words the Governor may make rules regulating had been substituted and A. Since for clause a. The following clause had been substituted, namely a. The constitution of village councils and courts, the powers to be exercised by them under this paragraph and the courts to which appeals from the decisions of village councils and courts shall lie. A. Since for clause c. The following clause had been substituted, namely c. The transfer of appeals and other proceedings pending before the regional or district council or any court constituted by such council immediately before the date appointed by the President under subparagraph 5, and A. Since in clause e. For the words, brackets and figures subparagraphs 1 and 2, the word, brackets and figure subparagraph 1, had been substituted. 5. Conferment of powers under the Code of Civil Procedure, 1908, and the Code of Criminal Procedure, 1898, on the regional and district councils and on certain courts and officers for the trial of certain suits, cases and offences. 1. The Governor may, for the trial of suits or cases arising out of any law in force in any autonomous district or region being a law specified in that behalf by the Governor, or for the trial of offences punishable with death, transportation for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to such district or region, confer on the district council or the regional council having authority over such district or region or on courts constituted by such district council or on any officer appointed in that behalf by the Governor, such powers under the Code of Civil Procedure, 1908, or as the case may be, the Code of Criminal Procedure, 1898, as he deems appropriate. And thereupon the said council, court or officer shall try the suits, cases or offences in exercise of the powers so conferred. 2. The governor may withdraw or modify any of the powers conferred on a district council, regional council, court or officer under subparagraph 1 of this paragraph. 3. Save as expressly provided in this paragraph, the Code of Civil Procedure, 1908, and the Code of Criminal Procedure, 1,898,593, shall not apply to the trial of any suits, cases or offences in an autonomous district or in any autonomous region to which the provisions of this paragraph apply. 4. On and from the date appointed by the President under subparagraph 5 of paragraph 4 in relation to any autonomous district or autonomous region, nothing contained in this paragraph shall, in its application to that district or region, be deemed to authorize the governor to confer on the district council or regional council or on courts constituted by the district council any of the powers referred to in subparagraph 1 of this paragraph. 6. Powers of the district council to establish primary schools, etc. 1. The district council for an autonomous district may establish, construct, or manage primary schools, dispensaries, markets, 596 cattle pounds, ferries, fisheries, roads, road transport and waterways in the district and may, with the previous approval of the governor, make regulations for the regulation and control thereof and, in particular, may prescribe the language and the manner in which primary education shall be imparted in the primary schools in the district. 2. The governor may, with the consent of any district council, entrust either conditionally or unconditionally to that council or to its officers functions in relation to agriculture, animal husbandry, community projects, cooperative societies, social welfare, village planning or any other matter to which the executive power of the state extends. 7. District and regional funds. 1. There shall be constituted for each autonomous district, a district fund, and for each autonomous region, a regional fund, to which shall be credited all monies received respectively by the district council for that district and the regional council for that region in the course of the administration of such district or region, as the case may be, in accordance with the provisions of this Constitution. 2. The governor may make rules for the management of the district fund, or, as the case may be, the regional fund, and for the procedure to be followed in respect of payment of money into the said fund, the withdrawal of monies therefrom, the custody of monies therein, and any other matter connected with or ancillary to the matters aforesaid. 3. The accounts of the district council or, as the case may be, the regional council shall be kept in such form as the Comptroller and Auditor General of India may, with the approval of the President, prescribe. 4. The Comptroller and Auditor General shall cause the accounts of the district and regional councils to be audited in such manner as he may think fit, and the reports of the Comptroller and Auditor General relating to such accounts shall be submitted to the Governor, who shall cause them to be laid before the Council. 8. Powers to assess and collect land revenue and to impose taxes. 1. The Regional Council for an autonomous region in respect of all lands within such region, and the District Council for an autonomous district in respect of all lands within the district except those which are in the areas under the authority of regional councils, if any, within the district, shall have the power to assess and collect revenue in respect of such lands in accordance with the principles for the time being followed 599 by the government of the state in assessing lands for the purpose of land revenue in the state generally. 2. The Regional Council for an autonomous region in respect of areas within such region, and the District Council for an autonomous district in respect of all areas in the district except those which are under the authority of regional councils, if any, within the district, shall have power to levy and collect taxes on lands and buildings, and tolls on persons resident within such areas. 3. The District Council for an autonomous district shall have the power to levy and collect all or any of the following taxes within such district, that is to say, a cents taxes on professions, trades, callings and employments. A cents taxes on animals, vehicles and boats. A cents taxes on the entry of goods into a market for sale therein, and tolls on passengers and goods carried in ferries. A cents taxes for the maintenance of schools, dispensaries or roads and a cents taxes on entertainment and amusements. 4. A regional council or district council, as the case may be, may make regulations to provide for the levy and collection of any of the taxes specified in subparagraphs 2 and 3 of this paragraph 600, and every such regulation shall be submitted forthwith to the governor and, until assented to by him, shall have no effect. 9. Licenses or leases for the purpose of prospecting for, or extraction of, minerals. 1. Such share of the royalties accruing each year from licenses or leases for the purpose of prospecting for, or the extraction of, minerals granted by the government of the state in respect of any area within an autonomous district as may be agreed upon between the government of the state and the district council of such district shall be made over to that district council. 2. If any dispute arises as to the share of such royalties to be made over to a district council, it shall be referred to the governor for determination, and the amount determined by the governor in his discretion shall be deemed to be the amount payable under subparagraph 1 of this paragraph to the district council, and the decision of the governor shall be final. 10. Power of district council to make regulations for the control of money lending and trading by non-tribals. 1. The District Council of an autonomous district may make regulations for the regulation and control of money lending or trading within the district by persons other than scheduled tribes resident in the district. 2. In particular and without prejudice to the generality of the foregoing power, such regulations may I prescribe that no one except the holder of a license issued in that behalf shall carry on the business of money lending. I prescribe the maximum rate of interest which may be charged or be recovered by a moneylender. A provide for the maintenance of accounts by moneylenders and for the inspection of such accounts by officers appointed in that behalf by the district council. I prescribe that no person who is not a member of the scheduled tribes resident in the district shall carry on wholesale or retail business in any commodity except under a license issued in that behalf by the district council. Provided that no regulations may be made under this paragraph unless they are passed by a majority of not less than 3/4 of the total membership of the district council. Provided further that it shall not be competent under any such regulations to refuse the grant of a license to a moneylender or a trader who has been carrying on business within the district since before the time of the making of such regulations. 3. All regulations made under this paragraph shall be submitted forthwith to the governor and, until assented to by him, shall have no effect. 11. Publication of laws, rules and regulations made under the schedule. All laws, rules and regulations made under this schedule by a district council or a regional council shall be published forthwith in the official gazette of the state and shall on such publication have the force of law. 12. Application of Acts of Parliament and of the Legislature of the State of Assam to autonomous districts and autonomous regions in the State of Assam. 1. Notwithstanding anything in this Constitution, I no act of the Legislature of the State of Assam in respect of any of the matters specified in paragraph 3 of this schedule as matters with respect to which a district council or a regional council may make laws, and no act of the Legislature of the State of Assam prohibiting or restricting the consumption of any non-distilled alcoholic liquor shall apply to any autonomous district or autonomous region 609 inches that state, unless in either case the district council for such district or having jurisdiction over such region by public notification so directs. and the District Council in giving such direction with respect to any act may direct that the act shall in its application to such district or region or any part thereof have effect subject to such exceptions or modifications as it thinks fit. Since the Governor may, by public notification, direct that any Act of Parliament or of the Legislature of the State of Assam to which the provisions of Clause A of this subparagraph do not apply, shall not apply to an autonomous district or an autonomous region in that state, or shall apply to such district or region or any part thereof subject to such exceptions or modifications as he may specify in the notification. 2. Any direction given under subparagraph 1 of this paragraph may be given so as to have retrospective effect. 12a. Application of Acts of Parliament and of the Legislature of the State of Meghalaya to autonomous districts and autonomous regions in the State of Meghalaya. Notwithstanding anything in this Constitution, 1. If any provision of a law made by a district or regional council in the State of Meghalaya with respect to any matter specified in subparagraph 1 of paragraph 3 of this schedule, or if any provision of any regulation made by a district council or a regional council in that state under paragraph 8 or paragraph 10 of this schedule, is repugnant to any provision of the law made by the legislature of the State of Meghalaya with respect to that matter, then, the law or regulation made by the district council or, as the case may be, the regional council, whether made before or after the law made by the legislature of the State of Meghalaya, shall, to the extent of repugnancy, be void, and the law made by the legislature of the State of Meghalaya shall prevail. 2. The President may, with respect to any Act of Parliament, by notification, direct that it shall not apply to an autonomous district or an autonomous region in the State of Meghalaya, or shall apply to such district or region or any part thereof subject to such exceptions or modifications as he may specify in the notification, and any such direction may be given so as to have retrospective effect. 12r. Application of Acts of Parliament and of the Legislature of the State of Tripura to the autonomous district and autonomous regions in the State of Tripura. Notwithstanding anything in this Constitution, 1. No act of the legislature of the State of Tripura in respect of any of the matters specified in paragraph 3 of this schedule as matters with respect to which a district council or a regional council may make clause, and no act of the legislature of the State of Tripura prohibiting or restricting the consumption of any non-distilled alcoholic liquor shall apply to the autonomous district or an autonomous region in that state unless, in either case, the district council for that district or having jurisdiction over such region by public notification so directs, and the district council in giving such direction with respect to any act may direct that the act shall, in its application to that district or such region or any part thereof, have effect subject to such exceptions or modifications as it thinks fit. 2. The Governor may, by public notification, direct that any act of the legislature of the State of Tripura to which the provisions of Clause A of the subparagraph do not apply, shall not apply to the autonomous district or an autonomous region in that state, or shall apply to that district or such region, or any part thereof, subject to such exceptions or modifications, as he may specify in the notification. 3. The President may, with respect to any Act of Parliament, by notification, direct that it shall not apply to the autonomous district or an autonomous region in the State of Tripura, or shall apply to such district or region or any part thereof, subject to such exceptions or modifications as he may specify in the notification, and any such direction may be given so as to have retrospective effect. 12b. Application of Acts of Parliament and of the Legislature of the State of Mizoram to autonomous districts and autonomous regions in the State of Mizoram. Notwithstanding anything in this Constitution, 1. No act of the legislature of the state of Mizoram in respect of any of the matters specified in paragraph 3 of this schedule as matters with respect to which a district council or a regional council may make laws, and no act of the legislature of the state of Mizoram prohibiting or restricting the consumption of any non-distilled alcoholic liquor shall apply to any autonomous district or autonomous region in that state unless, in either case, the district council for such district or having jurisdiction over such region, by public notification, so directs, and the district council, in giving such direction with respect to any act, may direct that the act shall, in its application to such district or region or any part thereof, have effect subject to such exceptions or modifications as it thinks fit. 2. The governor may, by public notification, direct that any act of the legislature of the state of Mizoram to which the provisions of clause A of this subparagraph do not apply, shall not apply to an autonomous district or an autonomous region in that state, or shall apply to such district or region, or any part thereof, subject to such exceptions or modifications, as he may specify in the notification. 3. The President may, with respect to any act of Parliament, by notification, direct that it shall not apply to an autonomous district or an autonomous region in the state of Mizoram, or shall apply to such district or region or any part thereof, subject to such exceptions or modifications as he may specify in the notification, and any such direction may be given so as to have retrospective effect. 13. Estimated receipts and expenditure pertaining to autonomous districts to be shown separately in the annual financial statement. The estimated receipts and expenditure pertaining to an autonomous district which are to be credited to, or is to be made from, the consolidated fund of the state shall be first placed before the district council for discussion, and then after such discussion be shown separately in the annual financial statement of the state to be laid before the legislature of the state under Article 202. 14. Appointment of commission to inquire into and report on the administration of autonomous districts and autonomous regions. 1. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous districts and autonomous regions in the state, including matters specified in clauses C, D, E, and F of subparagraph 3 of paragraph 1 of this schedule, or may appoint a commission to inquire into and report from time to time on the administration of autonomous districts and autonomous regions in the state generally and in particular on a. Since the provision of educational and the medical facilities and communications in such districts and regions. A. Since the need for any new or special legislation in respect of such districts and regions, and I. Since the administration of the laws, rules and regulations made by the district and regional councils, and define the procedure to be followed by such commission. 2. The report of every such commission with the recommendations of the governor with respect thereto shall be laid before the legislature of the state by the minister concerned, together with an explanatory memorandum regarding the action proposed to be taken thereon by the government of the state. 3. In allocating the business of the government of the state among his ministers, the governor may place one of his ministers specially in charge of the welfare of the autonomous districts and autonomous regions in the state. 15. Annulment or suspension of acts and resolutions of district and regional councils. 1. If at any time the governor is satisfied that an act or resolution of a district or a regional council is likely to endanger the safety of India 618 or is likely to be prejudicial to public order, he may annul or suspend such act or resolution and take such steps as he may consider necessary, including the suspension of the council and the assumption to himself of all or any of the powers vested in or exercisable by the council, to prevent the commission or continuance or such act, or the giving of effect to such resolution. 2. Any order made by the governor under subparagraph 1 of this paragraph together with the reasons therefore shall be laid before the legislature of the state as soon as possible, and the order shall, unless revoked by the legislature of the state, continue in force for a period of 12 months from the date on which it was so made. Provided that if and so often as a resolution approving the continuance in force of such order is passed by the legislature of the state, the order shall, unless cancelled by the governor, continue in force for a further period of 12 months from the date on which under this paragraph it would otherwise have ceased to operate. 16. Dissolution of a district or a regional council. 1. The governor may, on the recommendation of a commission appointed under paragraph 14 of this schedule, by public notification order the dissolution of a district or a regional council, and I direct that a fresh general election shall be held immediately for the reconstitution of the council, or I subject to the previous approval of the legislature of the state, assume the administration of the area under the authority of such council himself, or place the administration of such area under the commission appointed under the said paragraph, or any other body considered suitable by him for a period not exceeding 12 months. Provided that when an order under clause A of this paragraph has been made, the governor may take the action referred to in clause B of this paragraph with regard to the administration of the area in question pending the reconstitution of the council on fresh general election. Provided further that no action shall be taken under clause B of this paragraph without giving the district or the regional council, as the case may be, an opportunity of placing its views before the legislature of the state. 2. If at any time the governor is satisfied that a situation has arisen in which the administration of an autonomous district or region cannot be carried on in accordance with the provisions of this schedule, he may, by public notification, assume to himself all or any of the functions or powers vested in or exercisable by the district council, or, as the case may be, the regional council, and declare that such functions or powers shall be exercisable by such person or authority as he may specify in this behalf, for a period not exceeding 6 months. Provided that the governor may by a further order or orders extend the operation of the initial order by a period not exceeding 6 months on each occasion. 3. Every order made under subparagraph 2 of this paragraph with the reasons therefore shall be laid before the legislature of the state, and shall cease to operate at the expiration of 30 days from the date on which the state legislature first sits after the issue of the order, unless, before the expiry of that period, it has been approved by the state legislature. 17. Exclusion of areas from autonomous districts in forming constituencies in such districts for the purposes of elections to the Legislative Assembly of Assam or Meghalaya or Tripura or Mizoram. The governor may by order declare that any area within an autonomous district 625 inches the state of Assam or Meghalaya or Tripura or Mizoram, as the case may be, shall not form part of any constituency to fill a seat or seats in the assembly reserved for any such district, but shall form part of a constituency to fill a seat or seats in the assembly not so reserved to be specified in the order. 18. Omitted by S. 71I and 8th SCH, Ibid. WEF the 21st of January 1972, 19. Transitional provisions. 1. As soon as possible after the commencement of this constitution, the governor shall take steps for the constitution of a district council for each autonomous district in the state under this schedule, and, until a district council is so constituted for an autonomous district, the administration of such district shall be vested in the governor, and the following provisions shall apply to the administration of the areas within such district instead of the foregoing provisions of this schedule, namely: No act of Parliament or of the legislature of the state shall apply to any such area unless the governor by public notification so directs, and the governor in giving such a direction with respect to any act may direct that the act shall, in its application to the area or to any specified part thereof, have effect subject to such exceptions or modifications as he thinks fit. A sense the governor may make regulations for the peace and good government of any such area, and any regulations so made may repeal or amend any act of Parliament or of the legislature of the state, or any existing law which is for the time being applicable to such area. 2. Any direction given by the governor under clause A of subparagraph 1 of this paragraph may be given so as to have retrospective effect. 3. All regulations made under clause B of subparagraph 1 of this paragraph shall be submitted forthwith to the President and, until assented to by him, shall have no effect. 20. Tribal areas 1. The areas specified in parts 1, 2, IA and 3 of the table below shall respectively be the tribal areas within the state of Assam, the state of Meghalaya, the state of Tripura and the state of Mizoram. 2. Any reference in Part 1, Part 2 or Part 3 of the table below to any district shall be construed as a reference to the territories comprised within the autonomous district of that name existing immediately before the day appointed under Clause B of Section 2 of the Northeastern Areas Reorganization Act, 1971. Provided that for the purposes of clauses E and F of subparagraph 1 of paragraph 3, paragraph 4, paragraph 5, paragraph 6, subparagraph 2, clauses A, B, and D of subparagraph 3 and subparagraph 4 of paragraph 8 and clause D of subparagraph 2 of paragraph 10 of this schedule, no part of the area comprised within the municipality of Shillong shall be deemed to be within the Khasi Hills district. 3. The reference in Part IA in the table below to the Tripura Tribal Areas district shall be construed as a reference to the territory comprising the tribal areas specified in the first schedule to the Tripura Tribal Areas Autonomous District Council Act, 1979. Table Part 1-1. The North Kashgar Hills District. 2. 636 The Karbi Anglong District. Part 2-1. Khasi Hills District. 2. Jaintia Hills District. 3. The Garo Hills District. Part 2-8 Tripura Tribal Areas District. Part 3-1. The Chakma District. 2. The Mara District. 3. The Lai District. 20A. Dissolution of the Mizo District Council 1. Notwithstanding anything in this schedule, the District Council of the Mizo District existing immediately before the prescribed date, hereinafter referred to as the Mizo District Council, shall stand dissolved and cease to exist. 2. The Administrator of the Union Territory of Mizoram may, by one or more orders, provide for all or any of the following matters, namely: A. Since the transfer, in whole or in part, of the assets, rights and liabilities of the Mizo District Council, including the rights and liabilities under any contract made by it, to the Union or to any other authority. A. Since the substitution of the Union or any other authority for the Mizo District Council, or the addition of the Union or any other authority, as a party to any legal proceedings to which the Mizo District Council is a party. A. Since the transfer or re-employment of any employees of the Mizo District Council to or by the Union or any other authority, the terms and conditions of service applicable to such employees after such transfer or re-employment. A. Since the continuance of any laws, made by the Mizo District Council and in force immediately before its dissolution, subject to such adaptations and modifications, whether by way of repeal or amendment, as the Administrator may make in this behalf, until such laws are altered, repealed or amended by a competent legislature or other competent authority. I. Since such incidental, consequential and supplementary matters as the Administrator considers necessary. Explanation in this paragraph and in paragraph 20b of this schedule. The expression prescribed date means the date on which the Legislative Assembly of the Union Territory of Mizoram is duly constituted under and in accordance with the provisions of the Government of Union Territories Act, 1963. 20b. Autonomous regions in the Union Territory of Mizoram to be autonomous districts and transitory provisions consequent thereto. 1. Notwithstanding anything in this schedule, I since every autonomous region existing immediately before the prescribed date in the Union Territory of Mizoram shall, on and from that date, be an autonomous district in that Union Territory, hereafter referred to as the corresponding new district, and the administrator thereof may, by one or more orders, direct that such consequential amendments as are necessary to give effect to the provisions of this clause shall be made in paragraph 20 of this schedule, including Part 3 of the table appended to that paragraph, and thereupon the said paragraph and the said Part 3 shall be deemed to have been amended accordingly. Since every regional council of an autonomous region in the Union Territory of Mizoram existing immediately before the prescribed date, hereafter referred to as the existing regional council, shall, on and from that date and until a district council is duly constituted for the corresponding new district, be deemed to be the district council of that district, hereafter referred to as the corresponding new district council. 2. Every member, whether elected or nominated, of an existing regional council shall be deemed to have been elected or, as the case may be, nominated to the corresponding new district council, and shall hold office until a district council is duly constituted for the corresponding new district under this schedule. 3. Until rules are made under subparagraph 7 of paragraph 2 and subparagraph 4 of paragraph 4 of this schedule by the corresponding new district council, the rules made under the said provisions by the existing regional council and in force immediately before the prescribed date shall have effect in relation to the corresponding new district council, subject to such adaptations and modifications as may be made therein by the administrator of the Union Territory of Mizoram. 4. The administrator of the Union Territory of Mizoram may, by one or more orders, provide for all or any of the following matters, namely: A. Since the transfer in whole or in part of the assets, rights and liabilities of the existing regional council, including the rights and liabilities under any contract made by it, to the corresponding new district council. A. Since the substitution of the corresponding new district council for the existing regional council as a party to the legal proceedings to which the existing regional council is a party. A. Since the transfer or re-employment of any employees of the existing regional council to or by the corresponding new district council, the terms and conditions of service applicable to such employees after such transfer or re-employment. A. Since the continuance of any laws made by the existing regional council and in force immediately before the prescribed date, subject to such adaptations and modifications, whether by way of repeal or amendment, as the administrator may make in this behalf until such laws are altered, repealed or amended by a competent legislature or other competent authority. I. Since such incidental, consequential and supplementary matters as the administrator considers necessary. 20c. Interpretation. Subject to any provision made in this behalf, the provisions of this schedule shall, in their application to the Union Territory of Mizoram, have effect. 1. As if references to the governor and government of the state were references to the administrator of the Union Territory appointed under Article 239, references to state, except in the expression government of the state, were references to the Union Territory of Mizoram, and references to the state legislature were references to the Legislative Assembly of the Union Territory of Mizoram. 2. As if A. Since in subparagraph 5 of paragraph 4, the provision for consultation with the government of the state concerned had been omitted. A. Since in subparagraph 2 of paragraph 6, for the words to which the executive power of the state extends, The words "with respect to which the Legislative Assembly of the Union Territory of Mizoram has power to make laws" had been substituted. A sentence in paragraph 13. The words and figures under Article 202 had been omitted. 21. Amendment of the Schedule 1. Parliament may from time to time by law amend by way of addition, variation or repeal any of the provisions of this schedule and, when the schedule is so amended, any reference to this schedule in this Constitution shall be construed as a reference to such schedule as so amended. 2. No such law as is mentioned in subparagraph 1 of this paragraph shall be deemed to be an amendment of this Constitution for the purposes of Article 368. 7th Schedule. Article 246, List I Union List 1. Defense of India and every part thereof including preparation for defense and all such acts as may be conducive in times of war to its prosecution and after its termination to effective demobilization. 2. Naval, military and air forces any other armed forces of the Union. 3. Deployment of any armed force of the Union or any other force subject to the control of the Union or any contingent or unit thereof in any state in aid of the civil powers, jurisdiction, privileges and liabilities of the members of such forces while on such deployment. 4. Delimitation of cantonment areas, local self-government in such areas, the constitution and powers within such areas of cantonment authorities and the regulation of house accommodation, including the control of rents, in such areas. 5. Naval, military and air force works. 6. Arms, firearms, ammunition and explosives. 7. Atomic energy and mineral resources necessary for its production. 8. Industries declared by Parliament by law to be necessary for the purpose of defense or for the prosecution of war. 9. Central Bureau of Intelligence and Investigation. 10. Preventive detention for reasons connected with defense, foreign affairs, or the security of India persons subjected to such detention. 11. Foreign affairs all matters which bring the Union into relation with any foreign country. 12. Diplomatic, consular and trade representation. 13. United Nations Organization. 14. Participation in international conferences, associations and other bodies and implementing of decisions made thereat. 15. Entering into treaties and agreements with foreign countries and implementing of treaties, agreements and conventions with foreign countries. 16. War and peace. 17. Foreign jurisdiction. 18. Citizenship, naturalization and aliens. 19. Extradition. 20. Admission into, and emigration and expulsion from, India passports and visas. 21. Pilgrimages to places outside India. 22. Piracies and crimes committed on the high seas or in the air, offences against the law of nations committed on land or the high seas or in the air. 23. Railways. 24. Highways declared by or under law made by Parliament to be national highways. 25. Shipping and navigation on inland waterways, declared by Parliament by law to be national waterways, as regards mechanically propelled vessels, the rule of the road on such waterways. 26. Maritime shipping and navigation, including shipping and navigation on tidal waters, provision of education and training for the mercantile marine and regulation of such education and training provided by states and other agencies. 27. Lighthouses, including lightships, beacons and other provision for the safety of shipping and aircraft. 28. Ports declared by or under law made by Parliament or existing law to be major ports, including their delimitation, and the constitution and powers of port authorities therein. 29. Port quarantine, including hospitals connected there with seamen's and marine hospitals. 30. Airways, aircraft and air navigation, provision of aerodromes, regulation and organization of air traffic and of aerodromes, provision for aeronautical education and training and regulation of such education and training provided by states and other agencies. 31. Carriage of passengers and goods by railway, sea or air, or by national waterways in mechanically propelled vessels. 32. Posts and telegraphs, telephones, wireless, broadcasting and other like forms of communication. 33. Property of the Union and the revenue therefrom, but as regards property situated in a state subject to legislation by the state, save in so far as Parliament by law otherwise provides. 34. Omitted by S. 26, Ibid. 35. Courts of wards for the estates of rulers of Indian states. 36. Public debt of the Union. 37. Currency, coinage and legal tender, foreign exchange. 38. Foreign loans. 39. Reserve Bank of India. 40. Post Office Savings Bank. 41. Lotteries organized by the Government of India or the Government of a state. 42. Trade and commerce with foreign countries, import and export across customs frontiers. Definition of customs frontiers. 43. Interstate trade and commerce. 44. Incorporation, regulation and winding up of trading corporations, including banking, insurance and financial corporations but not including cooperative societies. 45. Incorporation, regulation and winding up of corporations, whether trading or not, with objects not confined to one state, but not including universities. 46. Banking. 47. Bills of exchange, checks, promissory notes and other like instruments. 48. Insurance. 49. Stock exchanges and futures markets. 50. Patents, inventions and designs, copyright, trademarks and merchandise marks. 51. Establishment of standards of weight and measure. 52. Establishment of standards of quality for goods to be exported out of India or transported from one state to another. 53. Industries, the control of which by the Union is declared by Parliament by law to be expedient in the public interest. 54. Regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. 55. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. 56. Regulation of labor and safety in mines and oil fields. 57. Regulation and development of interstate rivers and river valleys to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. 58. Fishing and fisheries beyond territorial waters. 59. Manufacture, supply and distribution of salt by Union agencies, regulation and control of manufacture, supply and distribution of salt by other agencies. 60. Cultivation, manufacture, and sale for export, of opium. 61. Sanctioning of cinematograph films for exhibition. 62. Industrial disputes concerning Union employees. 63. The institutions known at the commencement of this Constitution as the National Library, the Indian Museum, the Imperial War Museum, the Victoria Memorial and the Indian War Memorial, and any other like institution financed by the Government of India wholly or in part and declared by Parliament by law to be an institution of national importance. 64. The institutions known at the commencement of this constitution as the Benares Hindu University, the Aligarh Muslim University and the Delhi University, the university established in pursuance of Article 371E, any other institution declared by Parliament by law to be an institution of national importance. 65. Institutions for scientific or technical education financed by the Government of India wholly or in part and declared by Parliament by law to be institutions of national importance. 66. Union agencies and institutions for a sense professional, vocational or technical training, including the training of police officers or a sense the promotion of special studies or research or a sense scientific or technical assistance in the investigation or detection of crime. 67. Coordination and determination of standards in institutions for higher education or research and scientific and technical institutions. 68. Ancient and historical monuments and records, and archaeological sites and remains, declared by or under law made by Parliament to be of national importance. 69. The Survey of India, the Geological, Botanical, Zoological and Anthropological Surveys of India, meteorological organizations. 70. Census. 71. Union Public Services, All India Services, Union Public Service Commission. 72. Union pensions, that is to say, pensions payable by the Government of India or out of the Consolidated Fund of India. 73. Elections to Parliament, to the legislatures of states and to the offices of President and Vice President, the Election Commission. 74. Salaries and allowances of members of Parliament, the Chairman and Deputy Chairman of the Council of States and the Speaker and Deputy Speaker of the House of the People. 75. Powers, privileges and immunities of each House of Parliament and of the members and the committees of each House. Enforcement of attendance of persons for giving evidence or producing documents before committees of Parliament or commissions appointed by Parliament. 76. Emoluments, allowances, privileges, and rights in respect of leave of absence, of the President and Governor's salaries and allowances of the Ministers for the Union, the salaries, allowances, and rights in respect of leave of absence and other conditions of service of the Controller and Auditor General. 77. Audit of the accounts of the Union and of the States. 78. Constitution, organization, jurisdiction and powers of the Supreme Court, including contempt of such court, and the fees taken therein. Persons entitled to practice before the Supreme Court. 79. Constitution and organization. 650. Including vacations, of the High Courts except provisions as to officers and servants of High Courts. Persons entitled to practice before the High Courts. 80. Extension of the jurisdiction of a High Court to, and exclusion of the jurisdiction of a High Court from, any Union territory. 81. Extension of the powers and jurisdiction of members of a police force belonging to any state to any area outside that state, but not so as to enable the police of one state to exercise powers and jurisdiction in any area outside that state without the consent of the government of the state in which such area is situated. Extension of the powers and jurisdiction of members of a police force belonging to any state to railway areas outside that state. 82. Interstate migration, interstate quarantine. 83. Taxes on income other than agricultural income. 84. Duties of customs including export duties. 85. Duties of excise on the following goods manufactured or produced in India, namely: A cents petroleum crude, A cents high-speed diesel, A cents motor spirit, commonly known as petrol, A cents natural gas, A cents aviation turbine fuel and A cents tobacco and tobacco products. 86. Corporation tax. 87. Taxes on the capital value of the assets, exclusive of agricultural land, of individuals and companies. Taxes on the capital of companies. 88. Estate duty in respect of property other than agricultural land. 89. Duties in respect of succession to property other than agricultural land. 90. Terminal taxes on goods or passengers, carried by railway, sea or air, taxes on railway fares and freights. 91. Taxes other than stamp duties on transactions in stock exchanges and futures markets. 92. Rates of stamp duty in respect of bills of exchange, checks, promissory notes, bills of lading, letters of credit, policies of insurance, transfer of shares, debentures, proxies and receipts. 93. Omitted by the Constitution, 101st Amendment, Act, 2016, 94. Taxes on the sale or purchase of goods other than newspapers, where such sale or purchase takes place in the course of interstate trade or commerce. 95. Taxes on the consignment of goods, whether the consignment is to the person making it or to any other person, where such consignment takes place in the course of interstate trade or commerce. 96. Omitted by the Constitution, 101st Amendment, Act, 2016, 97. Offences against laws with respect to any of the matters in this list. 98. Inquiries, surveys and statistics for the purpose of any of the matters in this list. 99. Jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters in this list. Admiralty jurisdiction. 100. Fees in respect of any of the matters in this list, but not including fees taken in any court. 101. Any other matter not enumerated in List 2 or List 3, including any tax not mentioned in either of those lists. List 2. State List 1. Public order, but not including 654, the use of any naval, military or air force or any other armed force of the Union or of any other force subject to the control of the Union or of any contingent or unit thereof in aid of the civil power. 2. Police, including railway and village police, subject to the provisions of Entry 2A of List I. 3. Officers and servants of the High Court procedure in rent and revenue courts, fees taken in all courts except the Supreme Court. 4. Prisons, reformatories, borstal institutions and other institutions of a like nature, and persons detained therein, arrangements with other states for the use of prisons and other institutions. 5. Local government, that is to say, the constitution and powers of municipal corporations, improvement trusts, district boards, mining settlement authorities and other local authorities for the purpose of local self-government or village administration. 6. Public health and sanitation hospitals and dispensaries. 7. Pilgrimages, other than pilgrimages to places outside India. 8. Intoxicating liquors, that is to say, the production, manufacture, possession, transport, purchase and sale of intoxicating liquors. 9. Relief of the disabled and unemployable. 10. Burials and burial grounds, cremations and cremation grounds. 11. Omitted by S. 57, Ibid, WEF 3 January 1977, 12. Libraries, museums and other similar institutions controlled or financed by the state, ancient and historical monuments and records other than those 658 declared by or under law made by Parliament to be of national importance. 13. Communications, that is to say, roads, bridges, ferries, and other means of communication not specified in List I, municipal tramways, ropeways, inland waterways and traffic thereon, subject to the provisions of List I and List 3 with regard to such waterways, vehicles other than mechanically propelled vehicles. 14. Agriculture, including agricultural education and research, protection against pests and prevention of plant diseases. 15. Preservation, protection and improvement of stock and prevention of animal diseases, veterinary training and practice. 16. Pounds and the prevention of cattle trespass. 17. Water, that is to say, water supplies, irrigation and canals, drainage and embankments, water storage and water power subject to the provisions of Entry 56 of List I. 18. Land, that is to say, rights in or over land, land tenures including the relation of landlord and tenant, and the collection of rents, transfer and alienation of agricultural land, land improvement and agricultural loans, colonization. 19. Omitted by S. 57, Ibid, WEF 3 January 1977, 20. Omitted by S. 57, Ibid, WEF 3 January 1977, 21. Fisheries. 22. Courts of wards subject to the provisions of Entry 34 of List I encumbered and attached to states. 23. Regulation of mines and mineral development subject to the provisions of List I with respect to regulation and development under the control of the Union. 24. Industries subject to the provisions of 660 entries 7 and 52 of List I. 25. Gas and gas works. 26. Trade and commerce within the state subject to the provisions of Entry 33 of List III. 27. Production, supply and distribution of goods subject to the provisions of Entry 33 of List III. 28. Markets and fairs. 29. Omitted by the Constitution, 42nd Amendment, Act, 1976, S. 57, WEF 3 January 1977, 30. Moneylending and moneylenders' relief of agricultural indebtedness. 31. Inns and innkeepers. 32. Incorporation, regulation and winding up of corporations, other than those specified in List I, and universities, unincorporated trading, literary, scientific, religious and other societies and associations, cooperative societies. 33. Theatres and dramatic performances, cinemas subject to the provisions of Entry 60 of List I, sports, entertainments and amusements. 34. Betting and gambling. 35. Works, lands and buildings vested in or in the possession of the state. 36. Omitted by the Constitution, 7th Amendment, Act, 1956, S. 26. 37. Elections to the legislature of the state subject to the provisions of any law made by Parliament. 38. Salaries and allowances of members of the legislature of the state, of the Speaker and Deputy Speaker of the Legislative Assembly and, if there is a Legislative Council, of the Chairman and Deputy Chairman thereof. 39. Powers, privileges and immunities of the Legislative Assembly and of the members and the committees thereof, and, if there is a Legislative Council, of that council and of the members and the committees thereof. Enforcement of attendance of persons for giving evidence or producing documents before committees of the legislature of the state. 40. Salaries and allowances of ministers for the state. 41. State Public Services, State Public Service Commission. 42. State pensions, that is to say, pensions payable by the state or out of the consolidated fund of the state. 43. Public debt of the state. 44. Treasure trove. 45. Land revenue, including the assessment and collection of revenue, the maintenance of land records, survey for revenue purposes and records of rights, and alienation of revenues. 46. Taxes on agricultural income. 47. Duties in respect of succession to agricultural land. 48. Estate duty in respect of agricultural land. 49. Taxes on lands and buildings. 50. Taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. 51. Duties of excise on the following goods manufactured or produced in the state and countervailing duties at the same or lower rates on similar goods manufactured or produced elsewhere in India: A cents alcoholic liquors for human consumption. A cents opium, Indian hemp and other narcotic drugs and narcotics, but not including medicinal and toilet preparations containing alcohol or any substance included in subparagraph B of this entry. 52. Omitted by the Constitution, 101st Amendment, Act, 2016, 53. Taxes on the consumption or sale of electricity. 54. Taxes on the sale of petroleum crude, high-speed diesel, motor spirit, commonly known as petrol, natural gas, aviation turbine fuel and alcoholic liquor for human consumption, but not including sale in the course of interstate trade or commerce or sale in the course of international trade or commerce of such goods. 55. Omitted by the Constitution, 101st Amendment, Act, 2016, 56. Taxes on goods and passengers carried by road or on inland waterways. 57. Taxes on vehicles, whether mechanically propelled or not, suitable for use on roads, including tramcars subject to the provisions of Entry 35 of List 3. 58. Taxes on animals and boats. 59. Tolls. 60. Taxes on professions, trades, callings and employments. 61. Capitation taxes. 62. Taxes on entertainments and amusements to the extent levied and collected by a panchayat or a municipality or a regional council or a district council. 63. Rates of stamp duty in respect of documents other than those specified in the provisions of List I with regard to rates of stamp duty. 64. Offences against laws with respect to any of the matters in this list. 65. Jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters in this list. 66. Fees in respect of any of the matters in this list, but not including fees taken in any court. List 3. Concurrent List 1. Criminal law, including all matters included in the Indian Penal Code at the commencement of this Constitution but excluding offences against laws with respect to any of the matters specified in List I or List 2 and excluding the use of naval, military or air forces or any other armed forces of the Union in aid of the civil power. 2. Criminal procedure, including all matters included in the Code of Criminal Procedure at the commencement of this Constitution. 3. Preventive detention for reasons connected with the security of a state, the maintenance of public order, or the maintenance of supplies and services essential to the community persons subjected to such detention. 4. Removal from one state to another state of prisoners, accused persons and persons subjected to preventive detention for reasons specified in Entry 3 of this list. 5. Marriage and divorce, infants and minors, adoption, wills, intestacy and succession, joint family and partition, all matters in respect of which parties in judicial proceedings were immediately before the commencement of this Constitution subject to their personal law. 6. Transfer of property other than agricultural land, registration of deeds and documents. 7. Contracts, including partnership, agency, contracts of carriage, and other special forms or contracts, but not including contracts relating to agricultural land. 8. Actionable wrongs. 9. Bankruptcy and insolvency. 10. Trust and trustees. 11. Administrators general and official trustees. 12. Administration of justice, constitution and organization of all courts, except the Supreme Court and the High Courts. 13. evidence and oaths, recognition of laws, public acts and records, and rejudicial proceedings. 14. Civil procedure, including all matters included in the Code of Civil Procedure at the commencement of this Constitution, limitation and arbitration. 15. Contempt of court, but not including contempt of the Supreme Court. 16. Vagrancy, nomadic and migratory tribes. 17. Lunacy and mental deficiency, including places for the reception or treatment of lunatics and mental deficients. 18. Prevention of cruelty to animals. 19. Forests. 20. Protection of wild animals and birds. 21. Adulteration of foodstuffs and other goods. 22. Drugs and poisons, subject to the provisions of Entry 59 of List I with respect to opium. 23. Economic and social planning. 24. Population control and family planning. 25. Commercial and industrial monopolies, combines and trusts. 26. Trade unions, industrial and labor disputes. 27. Social security and social insurance, employment and unemployment. 28. Welfare of labor, including conditions of work, provident funds, employers' liability, workmen's compensation, invalidity and old age pensions and the maternity benefits. 29. Education, including technical education, medical education and universities, subject to the provisions of Entries 63, 64, 65 and 66 of List I. Vocational and technical training of labor. 30. Legal, medical and other professions. 31. Relief and rehabilitation of persons displaced from their original place of residence by reason of the setting up of the dominions of India and Pakistan. 32. Charities and charitable institutions, charitable and religious endowments and religious institutions. 33. Prevention of the extension from one state to another of infectious or contagious diseases or pests affecting men, animals or plants. 34. Vital statistics including registration of births and deaths. 35. Ports other than those declared by or under law made by Parliament or existing law to be major ports. 36. Shipping and navigation on inland waterways as regards mechanically propelled vessels, and the rule of the road on such waterways, and the carriage of passengers and goods on inland waterways subject to the provisions of List I with respect to national waterways. 37. Trade and commerce in, and the production, supply and distribution of cents the products of any industry where the control of such industry by the Union is declared by Parliament by law to be expedient in the public interest, and imported goods of the same kind as such products. Cents foodstuffs, including edible oil seeds and oils. Cents cattle fodder, including oil cakes and other concentrates. Cents raw cotton, whether ginned or unginned, and cottonseed and cents raw jute. 38. Weights and measures except establishment of standards. 39. Price control. 40. Mechanically propelled vehicles including the principles on which taxes on such vehicles are to be levied. 41. Factories. 42. Boilers. 43. Electricity. 44. Newspapers, books and printing presses. 45. Archaeological sites and remains other than those 670 declared by or under law made by Parliament to be of national importance. 46. Custody, management and disposal of property, including agricultural land, declared by law to be evacuee property. 47. Acquisition and requisitioning of property. 48. Recovery in a state of claims in respect of taxes and other public demands, including arrears of land revenue and sums recoverable as such arrears, arising outside that state. 49. Stamp duties other than duties or fees collected by means of judicial stamps, but not including rates of stamp duty. 50. Inquiries and statistics for the purposes of any of the matters specified in List 2 or List 3. 51. Jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters in this list. 52. Fees in respect of any of the matters in this list, but not including fees taken in any court. 8th Schedule. Languages, Articles 344(1) and 351, 1. Assamese. 2. Bengali. 3. Bodo. 4. Dogri. 5. Gujarati. 6. Hindi. 7. Kannada. 8. Kashmiri. 9. Konkani. 10. Maithili. 11. Malayalam. 12. Manipuri. 13. Marathi. 14. Nepali. 15. Odia. 16. Punjabi. 17. Sanskrit. 18. Santhali. 19. Sindhi. 20. Tamil. 21. Telugu. 22. Urdu. 9th Schedule. Article 31b, 1. The Bihar Land Reforms Act, 1950, Bihar Act 30 of 1950. 2. The Bombay Tenancy and Agricultural Lands Act, 1948, Bombay Act 67 of 1948. 3. The Bombay Malki Tenure Abolition Act, 1949, Bombay Act 61 of 1949. 4. The Bombay Talukdari Tenure Abolition Act, 1949, Bombay Act 62 of 1949. 5. The Panchmahal Tenure Abolition Act, 1949, Bombay Act 63 of 1949. 6. The Bombay Ghoti Abolition Act, 1950, Bombay Act 6 of 1950. 7. The Bombay Paragana and Kalkani Watan Abolition Act, 1950, Bombay Act 60 of 1950. 8. The Madhya Pradesh Abolition of Proprietary Rights, Estates, Mills, Alienated Lands, Act, 1950, Madhya Pradesh Act 1 of 1951. 9. The Madras Estates, Abolition and Conversion into Rotwari, Act, 1948, Madras Act 26 of 1948. 10. The Madras Estates, Abolition and Conversion into Rotwari, Amendment Act, 1950, Madras Act 1 of 1950. 11. The Uttar Pradesh Zamindari Abolition and Land Reforms Act, 1950, Uttar Pradesh Act 1 of 1951. 12. The Hyderabad Abolition of Jagirs, Regulation, 1358 F, No. Mulk 6 of 1358, Fasli. 13. The Hyderabad Jagirs, Commutation, Regulation, 1359 F, No. 25 of 1359, Fasli. 14. The Bihar Displaced Persons Rehabilitation, Acquisition of Land, Act, 1950, Bihar Act 38 of 1950. 15. The United Provinces Land Acquisition, Rehabilitation of Refugees, Act, 1948, UP Act 26 of 1948. 16. The Resettlement of Displaced Persons, Land Acquisition, Act, 1948, Act 60 of 1948. 17. Sections 52A to 52G of the Insurance Act, 1938, Act 4 of 1938, as inserted by Section 42 of the Insurance Amendment Act, 1950, Act 47 of 1950. 18. The Railway Companies Emergency Provisions Act, 1951, Act 51 of 1951. 19. Chapter 3 of the Industries, Development and Regulation Act, 1951, Act 65 of 1951, as inserted by Section 13 of the Industries, Development and Regulation Amendment Act, 1953, Act 26 of 1953. 20. The West Bengal Land Development and Planning Act, 1948, West Bengal Act 21 of 1948, as amended by West Bengal Act 29 of 1951. 21. The Andhra Pradesh Ceiling on Agricultural Holdings Act, 1961, Andhra Pradesh Act 10 of 1961. 22. The Andhra Pradesh, Telangana Area, Tenancy and Agricultural Lands, Validation Act, 1961, Andhra Pradesh Act 21 of 1961. 23. The Andhra Pradesh, Telangana Area, Ijara and Kali Land Cancellation of Irregular Patas and Abolition of Concessional Assessment Act, 1961, Andhra Pradesh Act 36 of 1961. 24. The Assam State Acquisition of Lands Belonging to Religious or Charitable Institution of Public Nature Act, 1959, Assam Act 9 of 1961. 25. The Bihar Land Reforms Amendment Act, 1953, Bihar Act 20 of 1954. 26. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Act, 1961, Bihar Act 12 of 1962. Except Section 28 of this Act. 27. The Bombay Talukdari Tenure Abolition Amendment Act, 1954, Bombay Act 1 of 1955. 28. The Bombay Talukdari Tenure Abolition Amendment Act, 1957, Bombay Act 18 of 1958. 29. The Bombay Inams, Kutch Area, Abolition Act, 1958, Bombay Act 98 of 1958. 30. The Bombay Tenancy and Agricultural Lands, Gujarat Amendment Act, 1960, Gujarat Act 16 of 1960. 31. The Gujarat Agricultural Lands Ceiling Act, 1960, Gujarat Act 26 of 1961. 32. The Sagbara and Mewasi Estates, Proprietary Rights Abolition, etc., Regulation, 1962, Gujarat Regulation I of 1962. 33. The Gujarat Surviving Alienations Abolition Act, 1963, Gujarat Act 33 of 1963, except insofar as this act relates to an alienation referred to in sub-clause D of Clause 3 of Section 2 thereof. 34. The Maharashtra Agricultural Lands, Ceiling on Holdings, Act, 1961, Maharashtra Act 27 of 1961. 35. The Hyderabad Tenancy and Agricultural Lands, Reenactment, Validation and Further Amendment, Act, 1961, Maharashtra Act 45 of 1961. 36. The Hyderabad Tenancy and Agricultural Lands Act 1950, Hyderabad Act 21 of 1950. 37. The Janmakram Payment, Abolition, Act, 1960, Kerala Act 3 of 1961. 38. The Kerala Land Tax Act, 1961, Kerala Act 13 of 1961. 39. The Kerala Land Reforms Act, 1963, Kerala Act 1 of 1964. 40. The Madhya Pradesh Land Revenue Code, 1959, Madhya Pradesh Act 20 of 1959. 41. The Madhya Pradesh Ceiling on Agricultural Holding Act, 1960, Madhya Pradesh Act 20 of 1960. 42. The Madras Cultivating Tenants Protection Act, 1955, Madras Act 25 of 1955. 43. The Madras Cultivating Tenants, Payment of Fair Rent, Act, 1956, Madras Act 24 of 1956. 44. The Madras Occupants of Kudirappu, Protection from Eviction, Act, 1961, Madras Act 38 of 1961. 45. The Madras Public Trusts, Regulation of Administration of Agricultural Lands, Act, 1961, Madras Act 57 of 1961. 46. The Madras Land Reforms, Fixation of Ceiling on Land, Act, 1961, Madras Act 58 of 1961. 47. The Mysore Tenancy Act, 1952, Mysore Act 13 of 1952. 48. The Coorg Tenants Act, 1957, Mysore Act 14 of 1957. 49. The Mysore Village Offices Abolition Act, 1961, Mysore Act 14 of 1961. 50. The Hyderabad Tenancy and Agricultural Lands, Validation, Act, 1961, Mysore Act 36 of 1961. 51. The Mysore Land Reforms Act, 1961, Mysore Act 10 of 1962. 52. The Orissa Land Reforms Act, 1960, Orissa Act 16 of 1960. 53. The Orissa Merged Territories, Village Offices Abolition, Act, 1963, Orissa Act 10 of 1963. 54. The Punjab Security of Land Tenures Act, 1953, Punjab Act 10 of 1953. 55. The Rajasthan Tenancy Act, 1955, Rajasthan Act 3 of 1955. 56. The Rajasthan Zamindari and Biswedari Abolition Act, 1959, Rajasthan Act 8 of 1959. 57. The Kumaon and Uttarakhand Zamindari Abolition and Land Reforms Act, 1960, Uttar Pradesh Act 17 of 1960. 58. The Uttar Pradesh Imposition of Ceiling on Land Holdings Act, 1960, Uttar Pradesh Act 1 of 1961. 59. The West Bengal Estates Acquisition Act, 1953, West Bengal Act 1 of 1954. 60. The West Bengal Land Reforms Act, 1955, West Bengal Act 10 of 1956. 61. The Delhi Land Reforms Act, 1954, Delhi Act 8 of 1954. 62. The Delhi Land Holdings, Ceiling, Act, 1960, Central Act 24 of 1960, 63. The Manipur Land Revenue and Land Reforms Act, 1960, Central Act 33 of 1960, 64. The Tripura Land Revenue and Land Reforms Act, 1960, Central Act 43 of 1960, 65. The Kerala Land Reforms, Amendment, Act, 1969, Kerala Act 35 of 1969, 66. The Kerala Land Reforms, Amendment, Act, 1971, Kerala Act 25 of 1971. 67. The Andhra Pradesh Land Reforms, Ceiling on Agricultural Holdings, Act, 1973, Andhra Pradesh Act 1 of 1973, 68. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Act, 1972, Bihar Act 1 of 1973, 69. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Act, 1973, Bihar Act 9 of 1973. 70. The Bihar Land Reforms, Amendment, Act, 1972, Bihar Act 5 of 1972, 71. The Gujarat Agricultural Land Ceiling, Amendment, Act, 1972, Gujarat Act 2 of 1974, 72. The Haryana Ceiling on Land Holdings Act, 1972, Haryana Act 26 of 1972, 73. The Himachal Pradesh Ceiling on Land Holdings Act, 1972, Himachal Pradesh Act 19 of 1973, 74. The Kerala Land Reforms, Amendment, Act, 1972, Kerala Act 17 of 1972, 75. The Madhya Pradesh Ceiling on Agricultural Holdings, Amendment, Act, 1972, Madhya Pradesh Act 12 of 1974, 76. The Madhya Pradesh Ceiling on Agricultural Holdings, Second Amendment, Act, 1972, Madhya Pradesh Act 13 of 1974. 77. The Mysore Land Reforms, Amendment, Act, 1973, Karnataka Act 1 of 1974. 78. The Punjab Land Reforms Act, 1972, Punjab Act 10 of 1973. 79. The Rajasthan Imposition of Ceiling on Agricultural Holdings Act, 1973, Rajasthan Act 11 of 1973. 80. The Gadala Janmam Estates, Abolition and Conversion into Rotwari, Act, 1969, Tamil Nadu Act 24 of 1969. 81. The West Bengal Land Reforms, Amendment, Act, 1972, West Bengal Act 12 of 1972, 82. The West Bengal Estates Acquisition, Amendment, Act, 1964, West Bengal Act 22 of 1964. 83. The West Bengal Estates Acquisition, Second Amendment, Act, 1973, West Bengal Act 33 of 1973. 84. The Bombay Tenancy and Agricultural Lands, Gujarat Amendment, Act, 1972, Gujarat Act 5 of 1973. 85. The Orissa Land Reforms, Amendment, Act, 1974, Orissa Act 9 of 1974. 86. The Tripura Land Revenue and Land Reforms, Second Amendment, Act, 1974, Tripura Act 7 of 1974. 87. Omitted by the Constitution, 44th Amendment, Act, 1978, S. 44, WEF the 20th of June 1979, 88. The Industries, Development and Regulation, Act, 1951, Central Act 65 of 1951, 89. The Requisitioning and Acquisition of a Movable Property Act, 1952, Central Act 30 of 1952. 90. The Mines and Minerals, Regulation and Development, Act, 1957, Central Act 67 of 1957, 91. The Monopolies and Restrictive Trade Practices Act, 1969, Central Act 54 of 1969. 92. Omitted by the Constitution, 44th Amendment, Act, 1978, S. 44, WEF the 20th of June 1979, 93. The Coking Coal Mines, Emergency Provisions, Act, 1971, Central Act 64 of 1971. 94. The Coking Coal Mines, Nationalization, Act, 1972, Central Act 36 of 1972. 95. The General Insurance Business, Nationalization, Act, 1972, Central Act 57 of 1972. 96. The Indian Copper Corporation, Acquisition of Undertaking, Act, 1972, Central Act 58 of 1972. 97. The Sikh Textile Undertakings, Taking Over of Management, Act, 1972, Central Act 72 of 1972. 98. The Coal Mines, Taking Over of Management, Act, 1973, Central Act 15 of 1973. 99. The Coal Mines, Nationalization, Act, 1973, Central Act 26 of 1973. 100. The Foreign Exchange Regulation Act, 1973, Central Act 46 of 1973. 101. The Alka Cashdown Company Limited, Acquisition of Undertakings, Act, 1973, Central Act 56 of 1973. 102. The Coal Mines, Conservation and Development, Act, 1974, Central Act 28 of 1974. 103. The Additional Emoluments, Compulsory Deposit, Act, 1974, Central Act 37 of 1974. 104. The Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, 1974, Central Act 52 of 1974. 105. The Sikh Textile Undertakings, Nationalization, Act, 1974, Central Act 57 of 1974. 106. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1964, Maharashtra Act 16 of 1965. 107. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1965, Maharashtra Act 32 of 1965. 108. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1968, Maharashtra Act 16 of 1968. 109. The Maharashtra Agricultural Lands, Ceiling on Holdings, Second Amendment, Act, 1968, Maharashtra Act 33 of 1968. 110. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1969, Maharashtra Act 37 of 1969. 111. The Maharashtra Agricultural Lands, Ceiling on Holdings, Second Amendment, Act, 1969, Maharashtra Act 38 of 1969. 112. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1970, Maharashtra Act 27 of 1970. 113. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1972, Maharashtra Act 13 of 1972. 114. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1973, Maharashtra Act 50 of 1973. 115. The Orissa Land Reforms, Amendment, Act, 1965, Orissa Act 13 of 1965. 116. The Orissa Land Reforms, Amendment, Act, 1966, Orissa Act 8 of 1967. 117. The Orissa Land Reforms, Amendment, Act, 1967, Orissa Act 13 of 1967. 118. The Orissa Land Reforms, Amendment, Act, 1969, Orissa Act 13 of 1969. 119. The Orissa Land Reforms, Amendment, Act, 1970, Orissa Act 18 of 1970. 120. The Uttar Pradesh Imposition of Ceiling on Land Holdings, Amendment, Act, 1972, Uttar Pradesh Act 18 of 1973. 121. The Uttar Pradesh Imposition of Ceiling on Land Holdings, Amendment, Act, 1974, Uttar Pradesh Act 2 of 1975. 122. The Tripura Land Revenue and Land Reforms, Third Amendment, Act, 1975, Tripura Act 3 of 1975. 123. The Dadra and Nagar Haveli Land Reforms Regulation, 1971, 3 of 1971. 124. The Dadra and Nagar Haveli Land Reforms, Amendment, Regulation, 1973, 5 of 1973. 125. Section 66A and Chapter of R of the Motor Vehicles Act, 1939, Central Act 4 of 1939. 126. The Essential Commodities Act, 1955, Central Act 10 of 1955. 127. The Smugglers and Foreign Exchange Manipulators, Forfeiture of Property, Act, 1976, Central Act 13 of 1976. 128. The Bonded Labor System, Abolition, Act, 1976, Central Act 19 of 1976. 129. The Conservation of Foreign Exchange and Prevention of Smuggling Activities, Amendment, Act, 1976, Central Act 20 of 1976. 130. Omitted by the Constitution, 44th Amendment, Act, 1978, S. 44, WEF the 20th of June 1979, 131. The Levy Sugar Price Equalization Fund Act, 1976, Central Act 31 of 1976. 132. The Urban Land, Ceiling and Regulation, Act, 1976, Central Act 33 of 1976. 133. The Departmentalization of Union Accounts, Transfer of Personnel, Act, 1976, Central Act 59 of 1976. 134. The Assam Fixation of Ceiling on Land Holdings Act, 1956, Assam Act 1 of 1957. 135. The Bombay Tenancy and Agricultural Lands, Vidarbha Region, Act, 1958, Bombay Act 99 of 1958. 136. The Gujarat Private Forests, Acquisition, Act, 1972, Gujarat Act 14 of 1973. 137. The Haryana Ceiling on Land Holdings, Amendment, Act, 1976, Haryana Act 17 of 1976. 138. The Himachal Pradesh Tenancy and Land Reforms Act, 1972, Himachal Pradesh Act 8 of 1974. 139. The Himachal Pradesh Village Common Lands Vesting and Utilization Act, 1974, Himachal Pradesh Act 18 of 1974. 140. The Karnataka Land Reforms, Second Amendment and Miscellaneous Provisions, Act, 1974, Karnataka Act 31 of 1974. 141. The Karnataka Land Reforms, Second Amendment, Act, 1976, Karnataka Act 27 of 1976. 142. The Kerala Prevention of Eviction Act, 1966, Kerala Act 12 of 1966. 143. The Thirupuvaram Payment, Abolition, Act, 1969, Kerala Act 19 of 1969. 144. The Sripadam Lands Enfranchisement Act, 1969, Kerala Act 20 of 1969. 145. The Sri Pandaravaka Lands, Vesting and Enfranchisement Act, 1971, Kerala Act 20 of 1971. 146. The Kerala Private Forests, Vesting and Assignment Act, 1971, Kerala Act 26 of 1971. 147. The Kerala Agricultural Workers Act, 1974, Kerala Act 18 of 1974. 147. The Kerala Cashew Factories Acquisition Act, 1974, Kerala Act 29 of 1974. 148. The Kerala Chitties Act, 1975, Kerala Act 23 of 1975. 149. The Kerala Scheduled Tribes, Restriction on Transfer of Lands and Restoration of Alienated Lands, Act, 1975, Kerala Act 31 of 1975. 150. The Kerala Land Reforms, Amendment, Act, 1976, Kerala Act 15 of 1976. 151. The Kannam Tenancy Abolition Act, 1976, Kerala Act 16 of 1976. 152. The Madhya Pradesh Ceiling on Agricultural Holdings, Amendment, Act, 1974, Madhya Pradesh Act 20 of 1974. 153. The Madhya Pradesh Ceiling on Agricultural Holdings, Amendment, Act, 1975, Madhya Pradesh Act 2 of 1976. 154. The West Khandish Mawasi Estates, Proprietary Rights Abolition, etc., Regulation, 1961, Maharashtra Regulation 1 of 1962. 155. The Maharashtra Restoration of Lands to Scheduled Tribes Act, 1974, Maharashtra Act 14 of 1975. 156. The Maharashtra Agricultural Lands, Lowering of Ceiling on Holdings, and Amendment, Act, 1972, Maharashtra Act 21 of 1975. 157. The Maharashtra Private Forests, Acquisition, Act, 1975, Maharashtra Act 29 of 1975. 158. The Maharashtra Agricultural Lands, Lowering of Ceiling on Holdings, and Amendment, Act, 1975, Maharashtra Act 47 of 1975. 159. The Maharashtra Agricultural Lands, Ceiling on Holdings, Amendment, Act, 1975, Maharashtra Act 2 of 1976. 160. The Orissa Estates Abolition Act, 1951, Orissa Act 1 of 1952. 161. The Rajasthan Colonization Act, 1954, Rajasthan Act 27 of 1954. 162. The Rajasthan Land Reforms and Acquisition of Landowners' Estates Act, 1963, Rajasthan Act 11 of 1964. 163. The Rajasthan Imposition of Ceiling on Agricultural Holdings, Amendment, Act, 1976, Rajasthan Act 8 of 1976. 164. The Rajasthan Tenancy, Amendment, Act, 1976, Rajasthan Act 12 of 1976. 165. The Tamil Nadu Land Reforms, Reduction of Ceiling on Land, Act, 1970, Tamil Nadu Act 17 of 1970. 166. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1971, Tamil Nadu Act 41 of 1971. 167. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1972, Tamil Nadu Act 10 of 1972. 168. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Second Amendment Act, 1972, Tamil Nadu Act 20 of 1972. 169. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Third Amendment Act, 1972, Tamil Nadu Act 37 of 1972. 170. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Fourth Amendment Act, 1972, Tamil Nadu Act 39 of 1972. 171. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Sixth Amendment Act, 1972, Tamil Nadu Act 7 of 1974. 172. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Fifth Amendment Act, 1972, Tamil Nadu Act 10 of 1974. 173. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1974, Tamil Nadu Act 15 of 1974. 174. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Third Amendment Act, 1974, Tamil Nadu Act 30 of 1974. 175. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Second Amendment Act, 1974, Tamil Nadu Act 32 of 1974. 176. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1975, Tamil Nadu Act 11 of 1975. 177. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Second Amendment Act, 1975, Tamil Nadu Act 21 of 1975. 178. Amendments made to the Uttar Pradesh Zamindari Abolition and Land Reforms Act, 1950, Uttar Pradesh Act 1 of 1951, by the Uttar Pradesh Land Laws, Amendment, Act, 1971, Uttar Pradesh Act, 21 of 1971, and Uttar Pradesh Land Laws, Amendment, Act, 1974, Uttar Pradesh Act 34 of 1974. 179. The Uttar Pradesh Imposition of Ceiling on Land Holdings, Amendment, Act, 1976, Uttar Pradesh Act 20 of 1976. 180. The West Bengal Land Reforms, Second Amendment, Act, 1972, West Bengal Act 28 of 1972. 181. The West Bengal Restoration of Alienated Land Act, 1973, West Bengal Act 23 of 1973. 182. The West Bengal Land Reforms, Amendment, Act, 1974, West Bengal Act 33 of 1974. 183. The West Bengal Land Reforms, Amendment, Act, 1975, West Bengal Act 23 of 1975. 184. The West Bengal Land Reforms, Amendment, Act, 1976, West Bengal Act 12 of 1976. 185. The Delhi Land Holdings, Ceiling, Amendment Act, 1976, Central Act 15 of 1976. 186. The Goa, Daman and Damandgar's Protection from Eviction, Act, 1975, Goa, Daman and Du Act 1 of 1976. 187. The Pondicherry Land Reforms, Fixation of Ceiling on Land, Act, 1973, Pondicherry Act 9 of 1974. 188. The Assam, Temporarily Settled Areas, Tenancy Act, 1971, Assam Act 23 of 1971. 189. The Assam, Temporarily Settled Areas, Tenancy, Amendment, Act, 1974, Assam Act 18 of 1974. 190. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Amending Act, 1974, Bihar Act 13 of 1975. 191. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Act, 1976, Bihar Act 22 of 1976. 192. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Act, 1978, Bihar Act 7 of 1978. 193. The Land Acquisition, Bihar Amendment, Act, 1979, Bihar Act 2 of 1980. 194. The Haryana Ceiling on Land Holdings, Amendment, Act, 1977, Haryana Act 14 of 1977. 195. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1978, Tamil Nadu Act 25 of 1978. 196. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1979, Tamil Nadu Act 11 of 1979. 197. The Uttar Pradesh Zamindari Abolition Laws, Amendment, Act, 1978, Uttar Pradesh Act 15 of 1978. 198. The West Bengal Restoration of Alienated Land, Amendment, Act, 1978, West Bengal Act 24 of 1978. 199. The West Bengal Restoration of Alienated Land, Amendment, Act, 1980, West Bengal Act 56 of 1980. 200. The Goa, Daman and Agricultural Tenancy Act, 1964, Goa, Daman and Act 7 of 1964. 201. The Goa, Daman and Agricultural Tenancy, Fifth Amendment, Act, 1976, Goa, Daman and Act 17 of 1976. 202. The Andhra Pradesh Scheduled Areas Land Transfer Regulation, 1959, Andhra Pradesh Regulation 1 of 1959. 203. The Andhra Pradesh Scheduled Areas Laws, Extension and Amendment, Regulation, 1963, Andhra Pradesh Regulation 2 of 1963. 204. The Andhra Pradesh Scheduled Areas Land Transfer, Amendment, Regulation, 1970, Andhra Pradesh Regulation 1 of 1970. 205. The Andhra Pradesh Scheduled Areas Land Transfer, Amendment, Regulation, 1971, Andhra Pradesh Regulation 1 of 1971. 206. The Andhra Pradesh Scheduled Areas Land Transfer, Amendment, Regulation, 1978, Andhra Pradesh Regulation 1 of 1978. 207. The Bihar Tenancy Act, 1885, Bihar Act 8 of 1885. 208. The Chotanag Tenancy Act, 1908, Bengal Act 6 of 1908 Chapter 8 Sections 46, 47, 48, 48A and 49 Chapter 10 Sections 71, 71A and 71B and Chapter 18 Sections 240, 241 and 242. 209. The Santhal Parganas Tenancy, Supplementary Provisions, Act, 1949, Bihar Act 14 of 1949, except Section 53. 210. The Bihar Scheduled Areas Regulation, 1969, Bihar Regulation 1 of 1969. 211. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Act, 1982, Bihar Act 55 of 1982. 212. The Gujarat Devasthan Inams Abolition Act, 1969, Gujarat Act 16 of 1969. 213. The Gujarat Tenancy Laws, Amendment, Act, 1976, Gujarat Act 37 of 1976. 214. The Gujarat Agricultural Land Ceiling, Amendment, Act, 1976, President's Act 43 of 1976. 215. The Gujarat Devasthan Inams Abolition, Amendment, Act, 1977, Gujarat Act 27 of 1977. 216. The Gujarat Tenancy Laws, Amendment, Act, 1977, Gujarat Act 30 of 1977. 217. The Bombay Land Revenue, Gujarat Second Amendment, Act, 1980, Gujarat Act 37 of 1980. 218. The Bombay Land Revenue Code and Land Tenure Abolition Laws, Gujarat Amendment, Act, 1982, Gujarat Act 8 of 1982. 219. The Himachal Pradesh Transfer of Land, Regulation, Act, 1968, Himachal Pradesh Act 15 of 1969. 220. The Himachal Pradesh Transfer of Land, Regulation, Amendment, Act, 1986, Himachal Pradesh Act 16 of 1986. 221. The Karnataka Scheduled Castes and Scheduled Tribes, Prohibition of Transfer of Certain Lands, Act, 1978, Karnataka Act 2 of 1979. 222. The Kerala Land Reforms, Amendment, Act, 1978, Kerala Act 13 of 1978. 223. The Kerala Land Reforms, Amendment, Act, 1981, Kerala Act 19 of 1981. 224. The Madhya Pradesh Land Revenue Code, Third Amendment, Act, 1976, Madhya Pradesh Act 61 of 1976. 225. The Madhya Pradesh Land Revenue Code, Amendment, Act, 1980, Madhya Pradesh Act 15 of 1980. 226. The Madhya Pradesh Krishik Jyotyukchatam Simuadinayam, 1981, Madhya Pradesh Act 11 of 1981. 227. The Madhya Pradesh Ceiling on Agricultural Holdings, Second Amendment, Act, 1976, Madhya Pradesh Act 1 of 1984. 228. The Madhya Pradesh Ceiling on Agricultural Holdings, Amendment, Act, 1984, Madhya Pradesh Act 14 of 1984. 229. The Madhya Pradesh Ceiling on Agricultural Holdings, Amendment, Act, 1989, Madhya Pradesh Act 8 of 1989. 230. The Maharashtra Land Revenue Code, 1966, Maharashtra Act 41 of 1966, Sections 36, 36A and 36B. 231. The Maharashtra Land Revenue Code and the Maharashtra Restoration of Lands to Scheduled Tribes, Second Amendment Act, 1976, Maharashtra Act 30 of 1977. 232. The Maharashtra Abolition of Subsisting Proprietary Rights to Mines and Minerals in Certain Lands Act, 1985, Maharashtra Act 16 of 1985. 233. The Orissa Scheduled Areas Transfer of Immovable Property, by Scheduled Tribes, Regulation, 1956, Orissa Regulation 2 of 1956. 234. The Orissa Land Reforms, Second Amendment, Act, 1975, Orissa Act 29 of 1976. 235. The Orissa Land Reforms, Amendment, Act, 1976, Orissa Act 30 of 1976. 236. The Orissa Land Reforms, Second Amendment, Act, 1976, Orissa Act 44 of 1976. 237. The Rajasthan Colonization, Amendment, Act, 1984, Rajasthan Act 12 of 1984. 238. The Rajasthan Tenancy, Amendment, Act, 1984, Rajasthan Act 13 of 1984. 239. The Rajasthan Tenancy, Amendment, Act, 1987, Rajasthan Act 21 of 1987. 240. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Second Amendment Act, 1979, Tamil Nadu Act 8 of 1980. 241. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1980, Tamil Nadu Act 21 of 1980. 242. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1981, Tamil Nadu Act 59 of 1981. 243. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Second Amendment Act, 1983, Tamil Nadu Act 2 of 1984. 244. The Uttar Pradesh Land Laws, Amendment, Act, 1982, Uttar Pradesh Act 20 of 1982. 245. The West Bengal Land Reforms, Amendment, Act, 1965, West Bengal Act 18 of 1965. 246. The West Bengal Land Reforms, Amendment, Act, 1966, West Bengal Act 11 of 1966. 247. The West Bengal Land Reforms, Second Amendment, Act, 1969, West Bengal Act 23 of 1969. 248. The West Bengal Estate Acquisition, Amendment, Act, 1977, West Bengal Act 36 of 1977. 249. The West Bengal Land Holding Revenue Act, 1979, West Bengal Act 44 of 1979. 250. The West Bengal Land Reforms, Amendment, Act, 1980, West Bengal Act 41 of 1980. 251. The West Bengal Land Holding Revenue, Amendment, Act, 1981, West Bengal Act 33 of 1981. 252. The Calcutta Thicket Tenancy, Acquisition and Regulation, Act, 1981, West Bengal Act 37 of 1981. 253. The West Bengal Land Holding Revenue, Amendment, Act, 1982, West Bengal Act 23 of 1982. 254. The Calcutta Thicket Tenancy, Acquisition and Regulation, Amendment, Act, 1984, West Bengal Act 41 of 1984. 255. The May Land Reforms Act, 1968, Pondicherry Act 1 of 1968. 256. The May Land Reforms, Amendment, Act, 1980, Pondicherry Act 1 of 1981. 257. The Tamil Nadu Backward Classes, Scheduled Castes and Scheduled Tribes, Reservation of Seats in Educational Institutions and of Appointments or Posts in the Services under the State, Act, 1993, Tamil Nadu Act 45 of 1994. 258. The Bihar Privileged Persons Homestead Tenancy Act, 1947, Bihar Act 4 of 1948. 259. The Bihar Consolidation of Holdings and Prevention of Fragmentation Act, 1956, Bihar Act 22 of 1956. 260. The Bihar Consolidation of Holdings and Prevention of Fragmentation, Amendment, Act, 1970, Bihar Act 7 of 1970. 261. The Bihar Privileged Persons Homestead Tenancy, Amendment, Act, 1970, Bihar Act 9 of 1970. 262. The Bihar Consolidation of Holdings and Prevention of Fragmentation, Amendment, Act, 1973, Bihar Act 27 of 1975. 263. The Bihar Consolidation of Holdings and Prevention of Fragmentation, Amendment, Act, 1981, Bihar Act 35 of 1982. 264. The Bihar Land Reforms, Fixation of Ceiling Area and Acquisition of Surplus Land, Amendment, Act, 1987, Bihar Act 21 of 1987. 265. The Bihar Privileged Persons Homestead Tenancy, Amendment, Act, 1989, Bihar Act 11 of 1989. 266. The Bihar Land Reforms, Amendment, Act, 1989, Bihar Act 11 of 1990. 267. The Karnataka Scheduled Castes and Scheduled Tribes, Prohibition of Transfer of Certain Lands, Amendment, Act, 1984, Karnataka Act 3 of 1984. 268. The Kerala Land Reforms, Amendment, Act, 1989, Kerala Act 16 of 1989. 269. The Kerala Land Reforms, Second Amendment, Act, 1989, Kerala Act 2 of 1990. 270. The Orissa Land Reforms, Amendment, Act, 1989, Orissa Act 9 of 1990. 271. The Rajasthan Tenancy, Amendment, Act, 1979, Rajasthan Act 16 of 1979. 272. The Rajasthan Colonization, Amendment, Act, 1987, Rajasthan Act 2 of 1987. 273. The Rajasthan Colonization, Amendment, Act, 1989, Rajasthan Act 12 of 1989. 274. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1983, Tamil Nadu Act 3 of 1984. 275. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment Act, 1986, Tamil Nadu Act 57 of 1986. 276. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Second Amendment Act, 1987, Tamil Nadu Act 4 of 1988. 277. The Tamil Nadu Land Reforms, Fixation of Ceiling on Land, Amendment, Act, 1989, Tamil Nadu Act 30 of 1989. 278. The West Bengal Land Reforms, Amendment, Act, 1981, West Bengal Act 50 of 1981. 279. The West Bengal Land Reforms, Amendment, Act, 1986, West Bengal Act 5 of 1986. 280. The West Bengal Land Reforms, Second Amendment, Act, 1986, West Bengal Act 19 of 1986. 281. The West Bengal Land Reforms, Third Amendment, Act, 1986, West Bengal Act 35 of 1986. 282. The West Bengal Land Reforms, Amendment, Act, 1989, West Bengal Act 23 of 1989. 283. The West Bengal Land Reforms, Amendment, Act, 1990, West Bengal Act 24 of 1990. 284. The West Bengal Land Reforms Tribunal Act, 1991, West Bengal Act 12 of 1991. Explanation: any acquisition made under the Rajasthan Tenancy Act, 1955, Rajasthan Act 3 of 1955, in contravention of the second proviso to clause 1 of Article 31A shall, to the extent of the contravention, be void,